Good afternoon. This panel is called corruption, which is a pretty broad term. And we're going to have 3 speakers on it. And after that, I hope some discussion and questions. Some years ago, when I was still at the bar, I had to cross-examine in the commercial court an American businessman about whom we had, shall I say, some information. Now, my first question to him was, what is your attitude to bribery? And he rather hesitated, so I said, well, I'll help you. Are you for it or against it? And his reply was, I'm against it, but not fanatically. And I rather think that that represents the views of quite a number of people and corporations, at least when they're dealing with the matter outside their own country. Something I've often heard and read of is that people who are questioned about their activities relating to bribery in other countries have what I've always regarded as the most feeble excuse for it. They say, well, everyone does it. Now, we're going to have 3 speakers today. We're going to have Advocate Thuli Madonsela. We're going to have Mr. Robert Barrington, and we're going to have Lord Hoffmann. And they will speak in that order. Now, Advocate Thuli Madonsela is an advocate of the High Court of South Africa. She has held many official or quasi-official or semi-official positions in South Africa. The most important is the one that she holds and has held since 2009, and that is the position of Public Protector. That is an office created by the Constitution of South Africa. And the main function of the Public Protector is to investigate and report on any allegations or suspicion of conduct in government or in public affairs which is or may be improper. Under the Constitution, she has independence, and what is required, of course, is sturdy independence and a high degree of competence. She's held that position since 2009, and under the Constitution, it's a position which is for a non-renewable 7-year term. In 2013 and 2014, she embarked on an investigation which followed some public allegations in connection with work done on improvements on the private residence of the state president. The work was ostensibly done for security reasons, but the allegations are that the work went beyond that. The allegations were thoroughly and confidentially, in the sense that there was no impairment of security in the broader sense. But after a thorough investigation, she gave her report. The report came to the conclusion, very clearly expressed, that the expenditure had been exorbitant and that a great deal of it was not for security purposes, but went beyond them and had resulted in a very great enhancement of the value of the president's private residence. just to give two examples of what were found to be work done, not for any genuine security reason, were the construction of a chicken run and a swimming pool. The report itself was very hard-hitting. It criticized several government departments. Now, during the investigation, and after it, when the report came out, the public protector was subjected to vicious and sustained political attacks by government supporters, both in and out of Parliament. She remained steadfast throughout. Every year, the General Council of the Bar of South Africa makes an award to an advocate or a judge who has made an exceptional contribution to law in South Africa. This year, the award was presented to Advocate Thuli Madonsela for her contribution to the rule of law and constitutional democracy in South Africa. Time magazine referred to her in one of its columns as an inspirational example of what African public officers need to do. She is going to talk to us on the role of administrative oversight on bodies in combating corruption. I'd ask her to speak to us now. Thank you.
Thank you, Sir Sidney Kentridge, and thank you to the Brick Court leadership for inviting me to this spectacular event. I'm particularly grateful to the key organizers, Mr. Harry Matofu, and a friend from South Africa, Advocate Jeremy Gauntlet, who to have gotten my name here. What Sidney Kentridge did not mention is that the award that I got recently is actually the Sidney and Felicia Kentridge Award. And I must say, apart from the honor of being here with the legal minds of the UK and selected legal minds from the African continent, part of my enthusiasm to come here and spend 24 hours in the UK and go back was the honor of being part of this panel. Sir Kentridge is somebody I've admired since I was a young lawyer. We modeled ourselves as lawyers involved in public interest law in what he and the Legal Resources Center and other lawyers were doing. It was interesting today to listen to somebody refer to him as peerless. It was also, of course, a particular opportunity to meet with UK lawyers and to thank you. Many of you, of course, all of you are young here, but many of you, of your parents and relatives, were part of the Legal Defense Fund and the anti-apartheid movement that made sure that we are where we are today. Well, it's not your problem. It's not, of course, your fault that we've missed a step here and there. The important thing is we're here together because we believe in the interconnectedness of humanity. And I thank Brick Chambers for focusing on Africa. And I like the heading or the theme, expanding legal horizons. Of course, in all good things, there's often something, a small thing that messes up the good thing. So this afternoon we have to talk a little bit about the little problem called corruption and how it may stand in the way of Africa rising and may have derailed or retarded progress since Africa began its rise, primarily during the decolonialization process, but more recently when leaders such as President Mbeki started talking about the African Renaissance again. We meet today at a time when Africa rising is on the agenda of the African continent. We have a document which maps up where we want to go as the African continent. It's called Agenda 2063, which is the Africa we want and the Africa we hope to arrive at by 2063, but one step at a time. The beauty of Agenda 2063 is an email written by Dr. Nkosazana Dlamini-Zuma to Kwame Nkrumah, where he talks about us having arrived. Of course, one of the things that are absent is corruption. And one of the things that are present when we've arrived is good governance. Another thing that is currently boosting our efforts at Africa Rising is a document called Silencing the Guns by 2020. That's 5 years from now. And the African continent has picked up that bad governance is one of the reasons there's conflict, including guns. And when we talk about silencing the guns, we're not only talking about the literal guns only, we're just talking about protests as well, including a protest that doesn't include guns. We are also fortunate in African countries at the moment that most African countries have decided to adopt strategic plans, not those 5-year plans that are linear, but more strategic plans that are more thought out in terms of the environment and risks and what needs to be done to get where we're going. In South Africa, for example, we have the National Development Plan. And all of these documents look at good governance, strengthening of institutions, strengthening of constitutional democracy as part of the journey if we are to arrive at the Africa we want. My talk is primarily, just very quickly, on the role of administrative oversight bodies, such as the Pub Protector, in combating corruption. In 2 days from now, on about the 30th of September, South African civil society organizations and individuals will be involved in a march against corruption. Although one of the groups is going to go to the Union Building, which is the seat of the executive, and another group will go to Parliament, which is the seat of the legislature. This march is not against the South African government, and it's not against any political party or company or person. It is a march by the people of South Africa saying that they can't look the other way in the face of corruption, regardless of whether or not it touches them directly. And this is a stand that they are taking. My office has said that we're encouraging everyone, including people from government, who want to take a stand against corruption and who are not saying they're against it, but not fanatically, to get involved in the march. Why is a march like this involved, and why is it important? Why am I mentioning the march? I actually believe, colleagues, that civic action, social movements, litigation, and institutions, administrative institutions, such as the Pub Protector, are increasingly becoming game changers when it comes to effectively combating corruption. We've seen civic action or people marching in countries such as Nicaragua, the Philippines, Brazil, and more recently in Malaysia. Why is it important to strengthen these synergies? And we know that corruption is a scourge. The abuse of power, the abuse of entrusted power for personal gain, according to Transparency International. Just very quickly, what does it take away from us as society? A lot. I'm just rushing. Corruption takes away a lot of things from society. One of the areas that we don't talk about a lot is the impact of corruption on policy. We know that corruption steals away resources, and we know from many international organizations, including the World Bank, that we're talking about trillions of dollars that are lost to corruption. In Africa alone, we know that we're talking about billions of dollars lost to corruption. However, what we don't talk a lot about is the impact on policy. You could have a policy moving in one direction, but because of corruption, it ends up going in a different direction. Your strategic priorities, you could have decided that with the money you have, some of the investigations we've done, for example, you have the money, you were supposed to hire more doctors, and somebody goes and buys video monitoring equipment. Well, in the case that we investigated or were investigating, and the video monitoring equipment does not even have the monitoring part. It's only just the videos first, only. So it doesn't, it's a white elephant, but the allegation being that it's due to corruption. Corruption derails development, and of course it siphons a huge amount of money from development into people's pockets. I want to quickly just talk about the role of institutions such as myself, the public protector. But before I talk about that, here are the figures. For example, the World Bank says we're losing 1 trillion paid as bribes globally. The World Economic Forum says that about 2.6 trillion was stolen through corruption from countries, which is about 5% of the global GDP. In Africa alone, it is estimated that 1/4 of the GDP of African states is lost to corruption. An institution such as the Public Protector is often misunderstood. Some people call us the public prosecutor. We're not the public prosecutor. I was very grateful that Kentridge explained what we are. It is an administrative oversight body. It has some similarities with what you have here as the ombudsman, but the similarities are like 1/3 of what we do, because we're an anti-corruption body, we're an ethics enforcement body as well. And the powers, if you look at the UK ombudsman, for example, has the power to investigate and report to Parliament. We have the power, as was read to you earlier, to investigate, report, and take appropriate remedial action. These institutions were introduced in South Africa by the new constitution, the 1996 constitution, and they're supposed to add more mechanisms to balance power. They add to what we call the traditional checks and balances, which is the trias politica, parliament, executive, and the legislature. They become part of a broader integrated integrity system, which includes the media, engaged civil society, and then these bodies are called administrative oversight bodies. Perhaps I should just talk very briefly about what do we do. We investigate anything that is alleged to be improper or suspected to be improper. Beyond the Constitution, we're given other powers by laws such as the Public Protector Act, which then gives us the power to investigate whatever is regarded as corrupt or as a corrupt activity under the Prevention and Combating of Corrupt Activities Act. I will give you the full paper and you will see that. We also are the only agency in South Africa that's given the power to enforce the Executive Ethics Code. And we are one of 2 agencies that are given the power to act as a safe harbor for whistleblowers, or a place where if you're a whistleblower, you can come to the Public Protector or the Auditor General and indicate that you think there was wrongdoing. And once you are on board, ideally you shouldn't suffer an occupational detriment. You should be protected from being fired or anything like that. There are challenges, though. I just wanted to talk about. There are a few challenges that we have had. The key challenge really is interpretation of the powers of the institution, that often there are no parallels to it. It's not a court, it's not part of the executive, it's not part of the legislature. The tendency then is to look at the ombudsman. So we're in court at the moment because somebody thought that Bradley said as an ombudsman you don't have the power to take appropriate remedial action, which is a court here, a case called Bradley. The reality is, of course, in the UK, an ombudsman is an important institution, but as you know, it's an administrative justice institution. It investigates maladministration, and it must report to Parliament. With us, we have to take appropriate remedial action, and we investigate corruption. But the key difference between the European Ombudsman and the Public Protector is that politicians are on the net or in the net of the people that have to be investigated. So you can't always count on politicians to be part of the enforcement mechanism. The important part of the enforcement mechanism, you need political will, but often you have to investigate Parliament itself. Often you have to investigate the acts of members of the executive, and you cannot always count on the kind of support that you need. Going forward, how can an institution such as the Public Protector, which you have in African countries, you'll find a similar institution in Rwanda, you'll find a similar institution in Uganda, Kenya, etc. How can they work better? Key to them is really having whistleblowers, the protection of whistleblowers. Secondly, it is important that we have strengthened synergies between this office and the prosecution. In other countries, what we're seeing emerging is what they call bounty laws, where the state can't prosecute, or you can prosecute and get the money yourself. In South Africa, we don't have those, but the whistleblowers are still important in the work we do because we investigate, and once we've investigated, we make a finding of maladministration. Even if a court were to decide that we don't have binding powers, that's not important. What's important is that once we've made a decision, people can take that document to court and enforce. The one case that was mentioned is one of those cases where people are trying to have it enforced. But one that has already been taken to court is SABC, where somebody was appointed without proper qualifications, but we found that he has wreaked havoc in the South African Broadcasting Corporation. The important thing is that when the matter was taken to court, the court found that because there was no irrationality in the decision I had made, then the government had to act in that case. Just in conclusion, what else can be done to combat corruption effectively, administratively? As I indicated, in terms of the broader system, cross-national prosecution is helpful, as we have seen with the FIFA. We're also involved with the Canadians and US in some of the cases. Reversing of tainted deals, we always worry about taking people to court and making sure that they go to prison. The work we do as the Public Protector South Africa, it's okay if they go to court, but the key is getting the money back so that the resources that have been taken out of development are clawed back and taken back into development. Secondly, if the deal is still fresh, we request that the deal should be reversed. We did that in some case called Against the Rules, where buildings were procured for a lease for headquarters of the police, and the process was flawed. And the decision was that the there was maladministration, there were gross irregularities, and there was overpricing and overbilling in terms of the building, and we asked that it be reversed. And the matter was taken to court. Up until now, the court agreed that the deal should be reversed. Just in ending, I was asked to speak very briefly. What do you do to ensure accountability in the case of corruption without regime change? My answer to that, colleagues, is that your game changers, as I said, is administrative oversight, litigation, and civic action. And that's what we've seen. I will answer some questions in the area across the board. Why administrative oversight are important is that unlike the courts are obviously they are the ultimate defense against corruption. There's no doubt about that. But the important thing about administrative oversight bodies is that anybody can approach them, including the people we refer to as Gogo Dlamini. So you don't have to have money to approach an administrative oversight body. And what you know about the law doesn't matter. We only want to know what you know about facts. And then we investigate to find out what happened, what should have happened. If there's a discrepancy, then we call it. And the other important game changer, of course, is civil society itself, because when the modern state is a powerful state, but in a country like ours, or in many of our countries, we have what we call proportional representation. Proportional representation means people do not represent constituencies, they are representatives of their party because they came on a party list. So often political oversight is not as strong as it could be or should be. And at that stage, these bodies, administrative bodies, become important. In fact, in ending, I would like to read from what former President Nelson Mandela said about these institutions when they were introduced in South Africa. He said the following, colleagues. Even the most benevolent of governments are made up of people with propensities for human failings. The rule of law, as we understand it, consists in the set of conventions and arrangements that ensure that it is not left to the whims of individual rulers to decide what is good for the populace. Administrative conduct of government and authorities are subject to the scrutiny of independent organs. It is this essential element of good governance that we have sought to have built into our new constitutional order. An essential part of that constitutional architecture is those institutions supporting constitutional democracy. Among those are the Public Protector, the Human Rights Commission, the Auditor General, the Independent Electoral Commission, the Commission on Gender Equality, the Constitutional Court, and others. What you get with these oversight bodies is that you get a united front then against corruption. On the one hand, you have Parliament, you have the executive with its own integrity bodies, such as statutory bodies against corruption, audit committees, and risk committees. Then you get the judiciary, you get civil society together with the media. Then you get these independent oversight bodies. If they work together and synergies are strengthened, we can certainly win the fight against corruption. Thank you again for your interest.
Mr. Barrington, who's going to speak next, will, I hope, not take it amiss if I say that he probably knows more about corruption than anyone else in this room. He is the executive director of a remarkable organization called Transparency International, which researches, comments on, advises on, exposes and combats corruption in all its forms, not only in this country, but throughout the world. Among other things, it publishes every year an index an international index of corruption as it is perceived by his organization throughout the world. It examines 175 countries. Number 1 on the list is the least corrupt. Number 175 is the most corrupt. In the latest index of 2014, the least corrupt were number 1, Denmark, and number 2, New Zealand. For the most corrupt, North Korea and Somalia tied at 174. South Africa, in company with Kuwait, held the not very distinguished ranking of number 67. The United Kingdom was number 14, and perhaps Mr. Barrington will tell us why it is not number 1. He will, no doubt, also indicate what are the types of corruption which his organization investigates. Is it simply bribery? Does it include really the peculation, the stealing of state assets by individual officials or politicians? What else does it possibly include? Perhaps political favoritism. Whatever it is, he knows about it, and I hope he'll tell us something about it.
Thank you very much, and thank you for inviting me here today. I'm in extraordinarily distinguished company and feeling not a little overawed, but I will tell you about what I know about, which is corruption. And I'll start with the thing I know most about, which is Transparency International. We're an anti-corruption organization, as Sir Sidney has said. We were founded in 1993, and we have chapters, as we call them, in around 100 countries worldwide, including South Africa, where our chapter is due to take part in the march that Thuli just mentioned. I run the chapter here in London, which consists of 35 people, half of whom are dedicated solely to looking at corruption in the defence and security sector. But I should reassure the First Sea Lord by saying that the strongest supporters of that programme are actually within the military, because they are those who are faced day in, day out around the world with having operations compromised by corruption, finding themselves in places in the first place due to corruption, and so on and so forth. And in fact, when you look at global security issues at the moment, whether it's Russia and Ukraine, whether it's Nigeria, Mali, Syria, Iran, Afghanistan, Pakistan, and so on, there is a clear thread of corruption that runs through in different ways in many, if not all, of those crises. And one anecdote I'll tell you about, which is a young Ukrainian who was seconded to our office from a Ukrainian ministry. And when he came to us, the war against, I say Russia, you all know what I mean, was just taking off. And in the middle of his time with us, he was called back to do military service. He was called up. And he wrote a fascinating article, which we managed to have published in the Western media, which talked about the dilemma that was facing him. He's somebody who loves his country, who wants to fight for his country. He could either pay $2,500 as a bribe to get a medical certificate that would enable him, a fake medical certificate, that would enable him not to go and serve in the front line, or he could use that same $2,500 to buy the equipment that was necessary in order for him to fight on the front line and have some chance of surviving. Why did he have to buy the equipment? Well, because the equipment was theoretically budgeted, of course, in the military, but the money had been stolen. So he had a choice of surviving by paying one kind of bribe or surviving by buying equipment that should have been provided by the state. So for us, day in, day out, we encounter these kind of little stories, whether it's in the defence sector or elsewhere, that really highlight the dangers that people face with regard to corruption. And I should say, I always like at some point in my talks to pay a small tribute to my colleagues around the world, whether it's in TI Russia or Sri Lanka or other chapters, who face intimidation, death threats, all sorts of nastiness. Some of my colleagues have been killed in the last few years. Fighting corruption is not an easy business. Here on my left is one of the bravest women you will ever meet. She's been very modest about it, but she does an extraordinarily difficult job in very difficult circumstances. This is really fighting corruption at the front line, and it's pretty dirty. Well, how bad is it? It's quite bad around the world. So Sydney mentioned our index. 175 countries we rank every year. Of those, you could set the pass mark where you like. We give countries a score and a rank. Say you set the pass mark at 50%. Well, sadly, any country that is lower than 55 on our table is scoring less than 50% on our index. So that's more than a third of the world, in terms of our countries, are scoring lower than 50% on our index. Well, that's not even a very high pass mark. And as for the UK, well, we're number 14. We used to be in the top 10. We could go into the reasons why the UK has slipped. But it shows, I think, that even in a country where there's a fairly good judicial system, legal structure, and so on, it's pretty hard, that this is not a simple thing. What about bribery? Well, we can draw the distinction, of course, between bribery and corruption. And I don't want to go into a lot of detail about definitions at the moment, but bribery in a way is the simplest form of corruption. It's both the most obvious, more easily identifiable than other forms like cronyism and so on. It itself is very widespread. We do another survey, which is an opinion survey of citizens, about 100,000 people around the world every couple of years, and we ask them very simple questions, like, have you paid a bribe in the last 12 months, and who have you paid it to, and how much did you pay, and so on. Well, the slightly dispiriting thing that across the world, more than 25% of people, the last time we did it, told us they had paid a bribe at least once in the last year. Of people who had come into contact with the police, that was 31%. And people who had come into contact with the judiciary, 24% of people around the world said that they had had to pay a bribe at least once in the past year. So this is fairly widespread. Of course, it's more prevalent in some countries than other, but there is also an argument that there are just different forms of corruption that are prevalent in advanced economies. So when you look at the UK, for example, albeit we're not doing as well as we used to, we're still 14th on that list of 175 countries. Not bad, you might think. But many of our chapters around the world will look at me and say, well, you needn't sit there so smugly in London because you're the cause of our problem. That if those who steal money from our countries couldn't save it in the City of London through the UK's Crown dependencies and overseas territories, couldn't buy houses in Kensington and Chelsea, couldn't put their children through public schools in the UK and private education, we wouldn't have the kind of problems in our country that we're facing. So you in the UK might not do so badly on these indices, but you're complicit in other ways. Well, that brings me to the Bribery Act. The UK Bribery Act 2010, why did we need it if we were doing quite well on these indices? Well, there were several reasons why we needed it. One was simply that we weren't complying with our international obligations under the OECD Anti-Bribery Convention. Another is that the UK law, as it had been in existence for a while, was very old, 1916, 1906. It needed rationalising and consolidating and was broadly not fit for purpose. But of course, what's interesting about the Bribery Act is that it managed to unleash a whole host of arguments about why the Bribery Act wasn't really necessary. From those who really, we imagine, wanted to carry on paying bribes. And so, of course, came up with all sorts of arguments about why it was not necessary, that it was out of line with US law, particularly on facilitation payments, that it was yet another example of the UK gold-plating its international obligations. By the way, the chair of the OECD Anti-Bribery Working Group said it was sort of middle of the road, the UK Bribery Act, so by no means gold-plating, and that it would prevent UK exports, as though it's okay to keep on bribing as long as that helps UK exports. So the usual arguments were rolled out. What's interesting from our point of view has been the impact of the Bribery Act, looking at it 5 years on. There was a government survey that was published a couple of months ago. Interestingly, this government survey had not been published for about 12 months, even though it had been commissioned. because the findings were not entirely in line with what some industry groups would have liked to say about the Bribery Act. But it was eventually published. It required quite a lot of pressure from various people, including Transparency International, to try and get it in the open. And it transpired that of UK companies that have heard of the Bribery Act, and some of them hadn't, more than 90% thought that this wasn't having any impact whatsoever on their ability to export. So that seemed to lay that issue to rest. But what we have seen is that UK companies broadly, particularly the larger ones, have tightened up their anti-corruption procedures. So I think it's had a very positive effect, at least on the procedures that one can see. And what's interesting also is that when you have a FTSE 100 company, of course, they'll have a supply chain of thousands, probably tens of thousands of suppliers, and it's driving that compliance through the supply chain as well. A small company in Malaysia, for example, wanting to be in part of Shell's supply chain, will now be Bribery Act compliant. We've also seen other jurisdictions looking at their legislation, seeing how it can be brought in line with the US equivalent, the FCPA and the UK Bribery Act. So interesting, a sort of raising of, at least from the legislative point of view, of bribery standards, anti-bribery standards worldwide. I want to touch now on just a few global corruption trends as we see them, which I hope you'll find of interest. And in the interest of time, I'll do them very briefly. The first is FIFA, which is fascinating to us at TI. Fascinating because, for two reasons really. The first is that what we often say in TI about corruption is let's look at the victims. When we're talking about the harm, let's see who the victims are. And of course in the FIFA instance, it's not like grand corruption from a head of state or corruption in the police force or the judiciary where you can find a direct victim. It's actually something that just touches people in the heart. It's a question of justice and the purity of the game and so on. And this has touched people worldwide, more than pretty much any other corruption issue we come across. So that's fascinating from our point of view. In fact, the most downloaded document from TI's website is our critique from 2011 on FIFA's governance. This is really demonstrating to us something about how corruption isn't just about the economic damage it does. It's about a sense of justice and fairness and all those other things. China, of course, is fascinating to watch, the so-called tigers and flies campaign of the Chinese government. China was very offended when it slipped down the Corruption Perceptions Index last year and said to us both publicly and privately, well, what about our tigers and flies campaign? To which we could only answer, well, since you're locking up anti-corruption campaigners and since there is no freedom of the press in China, it's actually very difficult to know what is really happening in China. We can see, of course, some visible examples of anti-corruption action, and that can only be positive, but it's difficult to know really what is happening. So a more transparent regime would probably get more credit. A couple of other trends. In New York this weekend, you'll have seen the UN launching its Sustainable Development Goals, the successor to the Millennium Development Goals. One of the interesting things there is that for the first time, there is a Sustainable Development Goal on governance, which includes specific indicators on bribery and corruption. So one of the trends we've witnessed in the last 20 years since TI's existed has been that this talk of governance and combating bribery and corruption has gradually risen to prominence in what world leaders have started to say and in all sorts of international mechanisms like the Sustainable Development Goals. When I talk about what world leaders have had to say, about 2 months ago, there were 2 interesting speeches in the same week. The President of the US in Kenya talking about corruption in the African context, and the Prime Minister of the UK in Singapore talking about corruption in the global context. So this is truly on the mind of global leaders in a way that 10 years ago one just wouldn't have been able to say. Finally, I want to talk about grand corruption and the issue of prosecuting grand corruption. What do you do when you have a head of state and his henchmen who are entirely corrupt? Do you just let it happen? Do you try and prosecute it somewhere other than in that country? What's your basis for doing that, and so on? Well, this is exercising people's minds enormously, none more so than us at TI. We elected a new global chair a year ago in Transparency International, somebody called Jose Ugaz that most of you will not have heard of probably, but if you've heard of one thing he's done, it will have been prosecuting the president of Peru, President Fujimori, and of course his head of security and hundreds of other Peruvian officials. He likewise is an enormously brave man. He has prosecuted corruption at the sharp end. And of course, one of his frustrations is looking around the world and seeing others who are like President Fujimori, who still maintain their presidential positions, or if they're retired, still retain their wealth. What can we do about that? Well, this very city that we're speaking in is severely implicated for all sorts of reasons. There are various legal mechanisms we're looking at, encouraged by our colleagues in France, who have been party to a case called Bien Mal Acquis. Those of you who follow obscure French legal cases will know about this. It's an attempt to seize the assets of three heads of state and their families, African heads of state, which the assets being located in France. Two interesting points about this. The first is that the anti-corruption movement has increasingly thought of going after assets rather than individuals. If we can't get the corrupt individual, can we at least make sure they don't enjoy the fruits of their corruption? And secondly, this issue of extraterritoriality. If the assets are not held in the origin country but in a destination country, how can we act against those, particularly when the authorities in the origin country are very unlikely to cooperate? So we're looking at those aspects of law. I'll just conclude by saying I think it's obvious from both of us who you've heard speaking today that corruption is indeed a global problem, and it's a bad problem, and some people say it's getting worse. TI is optimistic, however, and the grounds of optimism are both that it's on the agenda of global leaders in a way it never has been before, but secondly, we are witnessing across the world a transparency revolution, that corruption thrives in dark corners, in secrecy, in people not knowing about how things are done, not knowing about deals, whether it's in the defense sector or elsewhere. Social media have absolutely transformed this. There is more information about malfeasance with regard to corruption than ever before. We are overwhelmed with information. Our problem is actually how to manage and marshal and act on the information, not the availability of information, which would have been the case just a few years ago. So this transparency revolution, we think, has the opportunity to utterly transform the way in which corruption is perceived and dealt with worldwide, and that gives me grounds for optimism. Thank you.
Now I'm going to call upon Lord Hoffmann to speak. Lord Hoffmann is a retired Lord of Appeal. The title was Lord of Appeal in Ordinary, but there's not much that's ordinary about Lord Hoffmann. Lord Hoffmann, as I said, has retired from the bench. I have retired from the bar. So I no longer have to treat him as I used to, with the utmost respect. So I can be quite frank and objective about him. So all I can say, and all I need say, is that when he was a Lord of Appeal, he was the author of a series of judgments which were nothing less than brilliant, both in explaining the law and sometimes in revolutionizing the law. The elegance of his style has also made them real contributions to the literature of the law. Now, I have no idea at all of what he's going to say about corruption, but I think I can say that whatever it is, it's going to be original and fascinating. Lord Hoffmann.
Hard to live up to that. Thuli spoke from a country which is struggling to resist what seems to be a growing tide of corruption, which actually threatens civil society. And Robert gave you a conspectus of what the situation is throughout the world. What I'm going to offer you is a parochial postscript. I'm going to speak simply about corruption as it affects people like us, lawyers and those advising business in this country. And from a British point of view, corruption is largely a question of extraterritoriality. That is, it is primarily somebody else's problem, and the question is, what, if anything, should we do about it? As you were told, we come number 14 in Mr. Barrington's list, and it's true that the Scandinavian countries are at the very top, and we're just behind Germany. Of European countries, the lowest ranking is Italy, and I have to say that even South Africa and Ghana come higher on the list than Italy. Now, I wanted to start by considering the question of corruption in the judiciary, which is endemic in many countries, not only in Africa. When I was in the House of Lords, I remember we had a visit of some judges and the Minister of Justice from Kyrgyzstan. It's difficult to pronounce because it hasn't any vowels, which it ranks 136th on Mr. Barrington's list. And Lord Bingham and I received them in our little conference room, and Lord Bingham explained the role of the Appellate Committee of the House of Lords, and they listened politely. And at the end, the Minister of Justice said, but how do you deal with corruption among the judges? Well, I said the traditional English answer was, you pay them enough. And he thought about this, and he then said, well, maybe we should raise their salaries and take away their immunity from prosecution. I didn't know they had immunity from prosecution. But paying judges low salaries so that they lack public esteem and are tempted to accept bribes is one of the recognized techniques by which governments can eliminate the judiciary as an independent force which may restrict their power. It's unfortunate for the inhabitants of the country concerned, but there's nothing that we here can do about it. What we can do, and have done very successfully, is to offer an alternative form of adjudication to those who are in the position to take advantage of it. That is arbitration in London. I'm sometimes asked why international organizations, which have nothing to do with this country, often provide in their contracts that disputes are to be resolved by arbitration in London. Is it because it's cheaper? Not from what I've seen. Is it because of the confidentiality? Sometimes. But the main reason is that on no account do the parties want to litigate before the courts of the other party, or occasionally even their own, because they fear not only corruption, but also partiality and incompetence. Now, there's a special problem, which Thuli will know about, in South Africa, where the judiciary, it has to be said, lacks the talent and resources which are necessary to deal with difficult commercial cases. Now, that situation is perfectly understandable. When apartheid ended, the oppression which the black races had suffered meant that the existing judiciary was discredited in the eyes of the general public as having been in the front line of that oppression. And it was necessary to cast about and find judges in whose impartiality ordinary members of the public appearing before them, mostly in criminal trials, could have confidence. Appointing such judges was a matter of political necessity. but largely on account of poverty and the apartheid system of education, the pool of competent persons was not very large. So it wasn't surprising that judges who could conduct criminal trials might have no experience of being able to deal with complicated commercial cases. The answer was arbitration. And it does seem to be the case that arbitration has become popular there for domestic as well as for international commercial disputes. Now, you would have thought the South African government would have welcomed this development, which not only took some of the strain off the judicial system, but provided an opportunity for South Africa to become an arbitration center for disputes from other parts of Africa, as Mauritius is trying to become. Who would want to go to Mauritius if he could go to Cape Town? But the government has been doggedly resistant to the development of arbitration, apparently regarding it as an insult to the judiciary, and they've refused to update the 1965 South African Arbitration Act. And at one stage, they were even proposing to legislate to prohibit retired judges from acting as arbitrators. That seems to me an extraordinarily self-destructive attitude. Now, Robert spoke about the, I'm turned now to avoiding corruption disputes from here. Robert spoke about the Bribery Act of 2010, which was really the first time that we paid serious attention to the problem of UK-based companies using corruption to obtain business abroad. Now, the policy which underlines that act is largely the protection of our own national interest rather than attempting to improve standards of life in foreign countries, although that may be an incidental consequence. We're concerned with unethical behavior. We are concerned that unethical behavior by British firms abroad may cause reputational damage to British firms generally, just as Daimler-Benz and BMW are no doubt rather anxious in a way in which Renault is not. We want to lay down the boundaries as to what is legitimate competitive behavior, both between firms based in Britain and between such firms and foreign firms who may have the same advantages in subscribing to a similar code of conduct. And if that means it'll take a while before the Chinese see the advantages, well, so be it. Now, the act was, you may remember, highly controversial at the time. Much complaint from industry that it was too broad and vague in its scope, impossible to enforce, too expensive to comply with. It's now been enforced for 4 years, and Robert has referred to the report which has been produced. No one's been prosecuted for taking a Nigerian official to Twickenham. The criminal jurisdiction of the English courts over bribery abroad is broad, but not unlimited. A firm commits an offence if a person with whom it is associated, an employee or an overseas agent, offers a bribe. But this applies only to companies incorporated in the UK or which carry on business here. So it does not apply to, say, a wholly owned Kenyan subsidiary which doesn't carry on any business here. That's a matter for the Kenyans to deal with. Now, it's very interesting that, because you would have thought that that provides, a sort of easy loophole. If you want to get people to be bribed abroad, you incorporate a subsidiary and let them get on with it. And yet, that has, as far as I can see, not been happening. And that it makes one think that, and this is a point which Robert, I thought, made very well, that it's really the psychological effect of that act which is the important thing. It's not the question of the actual legal sanctions. It alters the atmosphere. And that therefore, you have UK multinational companies and so forth, which could find an easy means of escape, but which in fact don't, and which give effect to the principles in the Bribery Act. Now, the English courts can also intervene if foreigners who've given or accepted bribes come to England so that we can take jurisdiction over them, or if they find their assets find their way into the English property market or the English banking system. And that raises the question, well, are we doing too little? Robert gave the example of where you have the foreign government, which is going to do nothing to try and recover assets which have been brought to this company and invested in houses in Kensington or Hampstead Garden suburb. Ought we, of our own accord, to do something about it? People who become rich by plundering the oil resources of their own country. My view is that we should not. I think that the history of universal jurisdiction for any offences has not been a happy one. Even piracy iure gentium, where universal jurisdiction goes back to the Middle Ages, doesn't seem to be very popular today. Somali pirates are sometimes summarily shot, but I haven't read any reports of their being prosecuted. And if the First Sea Lord sends one of his frigates to patrol the Straits of Hormuz, I doubt they have instructions to bring anyone back for trial at the Old Bailey. At least I hope they don't. Few countries want to get involved in trying foreign criminals for offences which have nothing to do with them. Their judicial resources are usually overstretched dealing with domestic crime. So as far as we're concerned, it seems to me that in this country we have reasonably complied with our international obligations on foreign corruption. It would be better if we were higher up on the list, but otherwise I don't think that there's a great deal of a revolutionary kind which we here, looking at it from our parochial point of view, ought to do on this particular topic.
The panel will now answer any questions or comments which anyone here might like to make. And I'll look around the room. It's rather dark from here, but I'll look around the room to see who's going to... Well, here is someone who's going to lead off. Would you stand up, please, and indicate, just give your name or who you are, and then go ahead.
Can you all hear me at the back? My name is Hoffmann, and I'm studying law at the University of Essex. So I've read quite a lot of Lord Hoffmann's decisions relating to constitutional law. My basic question now is to Howard and Transparency International. There are two things that one needs to consider when we're talking about corruption. One I feel is, can you hear me now? So one of the things I feel needs to be considered is personal, what would you call it, personal view on what corruption is. So for instance, in Africa, there is a thing of gift giving. So you have a thing where someone decides, okay, you probably should get this as a gift. Is that considered by Transparency International when making, taking out surveys relating to the level of corruption in a particular country? Do you consider that there is a particular norm or custom in a country before deciding that, oh, that is corruption? Because what is in Africa might be different from the culture of gift giving in Africa is quite different from that in the UK. Thank you.
Thank you. I think I'm the obvious person to answer that question. I mean, yes, of course it is. You're quite right that you know, cultural norms differ around the world in all sorts of ways, and one has to take that into account if you're compiling a global survey. But on the other hand, I think that this is very important. There is a general global understanding about what corruption is, and definitions, wherever we try and put them together around the world in our 100 chapters, always coalesce around a common set of values about sort of justice and fairness and so on. it's quite interesting that although one can make the case, and it's often made in China as well, that certain types of gift giving are the norm, and that's quite acceptable. What you see happening in China at the moment is that it's the Chinese government themselves who are stamping out a lot of the gift giving, because it can tip over into being something that is not simply giving a gift to build a relationship. It's about something that's more abusive and inappropriate than that. And so what we tend to find is that across the world the sort of norms establish themselves. And indeed, the United Nations Convention Against Corruption is widely criticised for having been pretty useless. But where it is praised for being good is that it establishes essentially a kind of global understanding of what corruption is that I think now 140 countries have signed up to. So a short answer, yes, one always has to take into account local variance. But that's also the sort of scoundrel's route to trying to claim that bribery doesn't really count in my country.
Thank you. Right?
This is Aisha Abdallah. I'm from Kenya. I just had a comment to make. As a Kenyan, I think we consider the European and American lectures on corruption a bit rich because, for example, the Kenya government was forced to pay billions of dollars as a result of 2 UK London court judgments in Universal Sat Space and First Mercantile. And these are linked to well-known corruption on a grand scale. It's the largest amount of money stolen from the country. It's called the Anglo leasing scandal. It's on Wikipedia. The reason we had to pay this was, despite parliamentary objections, we had to raise money for critical infrastructure in the country, and we were held to ransom by 2 phantom companies created in offshore jurisdictions, and we would not be able to place our sovereign bond without those payments being made, and so we made them. But when we are lectured at Kenyans about our efforts to stamp out corruption, we do feel that our partners should actually assist more, and they could definitely do more in their jurisdictions. Thank you.
Thank you.
Actually, could I comment on that? I entirely agree, and therefore I disagree substantially with some of the things that Lord Hoffmann said by extrapolation.
Right, someone here.
Just a quick comment. Thank you. I just want to comment on the question of transnational bribery. That I do agree with you, Aisha, that collaboration from the countries where multinational companies come from, and oversight agencies in Africa and the developing world is important. It's not for me to make light of the comments that have been made. I do believe, though, from transparency, just a comment for the benefit of also Transparency International, is that often we look at how often is corruption reported as opposed to how endemic is corruption. Speaking for South Africa, for example, part of the reason we're always on the media about corruption is because we're doing something about it. I met a fellow 2 days ago, and I was speaking at a university, who was saying to me that he congratulates us in South Africa for pushing back against corruption. And if people in his country had pushed back as much as we're pushing, things would have been different, because in his country now they have reached a tipping point. So I'm just saying that from TI, that often it's important that the efforts that are being made are recognized. But I would not want to be apologetic about what is happening. I would rather say we need to join hands. In some of the cases that we're dealing with, for example, there is a joining hands. On one of the investigations that we're doing, Bombardier is an international company from Canada that is alleged to have bribed in South Africa, and they are investigating them in the mother country. We are investigating in South Africa. Where I suppose you may be right is that some of the OECD countries that do subscribe to the OECD Convention against the bribery of foreign public officials, they don't immediately act when it comes to bringing to justice or holding accountable alleged people from their countries who allegedly bribed foreign public officials. And one of the cases we have from our case, for example, is the arms deal. It's taken a while for those people to be brought to justice. Thank you.
Yes, can I? There's someone in front here. Do they have a microphone?
If there's time. Alistair Sutton from Brickcourt Chambers. If there's time to ask Robert a quick clarification point. You said the United Kingdom was 14th on the list. I just wondered, and you also mentioned about the overseas territories and crown dependencies, that ranking of 14th, does that take into account, is the UK, as it were, listed taking into account its responsibilities for its OTs and CDs? And secondly, really, do you think there's more the UK could do to improve the situation in the overseas territories and crown dependencies, taking into account the constitutional responsibilities, or division of responsibilities, should we say, between the UK and the OTs and CDs?
Thank you. Our index, I don't want to get into the sort of technicalities of how we construct the index, but the index is actually an index of perceptions. So it asks people like diplomats, country experts, journalists, and so on, how corrupt do you perceive this country to be versus another country, and then it gives them a rating based on that kind of survey. So it is actually just on the UK, but I would imagine that some people's perception of corruption in the UK, as we just heard from Kenya, is that our relationship with the Crown dependencies, particularly the overseas territories, which are notoriously non-transparent, I think is the polite term for it, it reflects badly on the UK. So although it is a rating just to the UK, I think our relationship with particularly the overseas territories is highly problematic. What can the UK do about it? Well, that is a subject of great discussion amongst anti-corruption groups at the moment. What seems to me to be part of the problem is not simply the issues about lack of transparency, but about, again, to use another synonym, just to be polite, the poor governance in many of those states, which of course are often very small states with very little capacity themselves to develop good governance systems and so on. So, I think that is a severe problem for Britain, and I absolutely just, repeat my support for the point from Kenya that notwithstanding Lord Hoffmann saying corruption is someone else's problem, when people are actually bringing the money here, putting their money through the UK educational system, buying houses here, using PR companies in London to launder their reputations, this is our problem, not everybody else's problem.
Do I see anyone else? I see a hand right up there at the back. Is there a microphone there? Thank you.
Thank you very much. My name is Fiona Darragh, and I'm a director of Protamos, and I've been pouncing on some of you over the course of the day. I wanted to make two remarks and possibly raise one question in relation to corruption. Our organisation has been working with communities who were involuntarily resettled in the wake of phase 1 of the Lesotho Highlands Water Project, which was the most extraordinary example of Western corporate corruption that you could possibly imagine. Every single major Western construction company and consultancy had its nose in the trough. And the Kingdom of Lesotho conducted for 10 years a set of completely extraordinary corruption trials in which the state prosecutor, led by the Attorney General, Fine Maima, managed to put together a full stretch of successful prosecutions with corresponding debarment by the World Bank. And I got up very close and personal with all of that. And phase 2 of the Lesotho Highlands Water Project now begins. And when one looks at the highly reputable construction companies who pitched for the first phase of the dam, one of the greatest concerns for me, who spent a lot of time working on corruption issues, is what will stop those companies from doing exactly as they did in phase 1 and bribing ruthlessly, either through local representatives or through setting up, as they did, numbered Swiss bank accounts for local employees. And so I come to the second point, which is that in Transparency International, there is a perceptions index, but on the other side of the page, there's also a bribe payers index. And I would submit to the assembled company that you can look at where you all are on the ratings nationally for perceptions of corruption. But the really interesting thing is when you turn the page and see who has the reputation for making corrupt payments. Because if there's one thing I learnt over the 10 years that I worked on these issues very closely, it is that this bribery is generally led by the people who offer the payments, not by the people who accept them. And I was wondering if Mr. Barrington had anything to add to that, or perhaps he disagrees with me.
Thank you. I'm a bit worried about hogging the panel, so I might just answer that very briefly, which is just to say...
Hog on.
Thank you. I'll hog on then. Just to say, I mean, of course, the issue of bribery, as Lord Hoffmann said, you know, I mean, the Bribery Act was to some extent aimed at UK companies bribing overseas because that was seen as a big part of other people's problem again. I think it's very interesting, one of the big recent scandals in sort of international bribery has been the Telia Sonera scandal in Scandinavia. I mean, the Scandinavian companies, one would imagine, are going to be squeaky clean. These are the countries top of our corruption perceptions index and so on. They went to a difficult country, Uzbekistan in one case, and found it very hard to operate there and submitted to the temptations. So, you know, I think the truth is that this isn't a simple world for companies, that they're operating in very complex environments where there are huge temptations, and sometimes if you're inexperienced in operating in those environments, it can be hard to know how you do business in a clean way. So, you know, I do have some sympathy for companies, while still, of course, believing that zero tolerance has to be the approach to this. I think we always have to remember that the biggest global bribery scandals to date have all been about companies in the US, the UK, Germany, Sweden, and so on. So this isn't the kind of story that one might imagine, that it's some countries have corruption and others don't.
Thank you very much. I'm afraid that's all we have time for, and I would like to thank the three speakers who came to speak to us this evening, and I would ask you now to thank them and in the usual way, and then we'll make way for the Admiral.